Thank you all for staying with us here at Live Now from Fox. My name is Carol Lajara, and a lot of legal headlines were made earlier this week concerning both Harvey Weinstein and also Alec Murdaugh. Let's start with Harvey Weinstein. The Associated Press reporting that the New York judge declared a mistrial on Friday in Weinstein's rape case from the Me Too era that has gone to trial 3 times so far after a jury was unable to come to a unanimous decision. The trial centered on whether Weinstein raped Jessica Mann, a hairstylist and actor, in 2013 during a relationship between the then-married Weinstein and the decades younger Mann. Weinstein's lawyers argued that the encounter was consensual, while Mann described a hotel room encounter when he forced himself upon her. A lot to discuss, specifically as to what comes next in this case and trial. Joining us next to do so is Brian Claypool. He is a criminal defense attorney. Brian, good morning. Thanks for joining.
Sure. Great to see you again, Carol.
Of course. All right, let's start with Harvey Weinstein, like I said. So this trial, it has gone on 3 times already. Brian, why has it been so hard for a jury to make a unanimous decision in this case?
Yeah, Carol, so sexual assault cases are difficult when you don't have what's called corroborating evidence. What do I mean by that? Where, for example, you have a potential eyewitness to it, or you have some physical evidence, such as a rape treatment kit that the victim went and participated in, within 24 or 48 hours of the alleged assault. Absent that type of evidence, it really becomes a he said, she said. And in this case with Mann, I really think the turning point for the jury to not convict was there was evidence that Miss Mann continued to communicate with Harvey Weinstein, 2, 3, 4 years out after the alleged assault. Now, the prosecutors brought in an expert that said, well, wait a minute, that's okay. That's typical of a sexual assault victim. But look, when you've got that big, challenge of proving, lack of consent, when a victim is still communicating with the perpetrator years later, that is persuasive to a jury.
Let's bring up some of the facts of this latest trial. So the current jury heard nearly 3 weeks of testimony, including from the accuser here, Jessica Mann. Weinstein decided not to testify. Brian, what is the purpose of that decision to not have Weinstein, as the person accused, get on the stand to give his side of the story?
Yeah, great question. The reason why, and by the way, that's a game time decision for most trial lawyers. Don't believe a trial lawyer who says, well, going into this, I knew I wasn't going to put on my client to testify at trial. I've done a lot of criminal trials, including, a very high profile case involving Dahlia DiPolito in South Florida. And we had a tough decision in that case, whether to put her on the stand or not. But look, at the end of the day, you have to look at where the evidence stands in the case at the time you have to decide whether to have your client take the stand. And I think what happened here is Weinstein's lawyers looked at whether the prosecution had met their burden of proof. They've got to prove, beyond a reasonable doubt with 12 jurors. And it's likely that, Weinstein's lawyer weighed the risk. Do I put him on there, have him be subjected to hours of cross-examination, and maybe he trips up. Maybe he doesn't, for example, come off sympathetic to a jury. That would be devastating to the defense case. But here, I think, you had, like you said, you had 2 prior mistrials. You've got the issue of whether the jury believes Mann. I'm not saying it didn't happen. But his lawyers felt like that's enough. And the burden of proof is not on the defense, Carell. It's on the prosecution.
Looking ahead now, there's a hearing set for June 24th for prosecutors to decide if they're going to go ahead with a 4th trial. Brian, what are some of the pros and cons of making that next step?
Yeah, well, I think one of the biggest factors that Alvin Bragg is going to have to consider, Carell, is that the jury voted 9-3 in favor of acquitting Weinstein. So he was only 3 jurors away from being, beating this crime basically, and being, free. Well, he wouldn't be a free man because he's got prior convictions and he's in jail. But look, when you're at 9-3, that's got to be persuasive to a prosecutor to not do this trial again, right? Carell, if it was, for example, 11-1 in favor of guilt, then maybe Bragg comes forward and does this again. So that's one big factor. And then the second big factor is the resources available to the New York City attorney. These trials cost a lot of money. I mentioned an expert witness prosecutors called. That's thousands and thousands of dollars. And then the manpower, the time, the energy of prosecutors and money can be used to prosecute other crimes within the city. And that's what Bragg's going to have to weigh. And I'll make a prediction here. I don't think he's going to go, to round 4 on this Mann trial.
I do want to point something else out, specifically when it comes to Harvey Weinstein. Brian, it was back in 2022 when he was convicted in Los Angeles, actually, for rape and sexual assault, sentenced to 16 years in prison. Does that fact have anything to do or play any kind of role within this specific New York case?
That's a great question, because that applies now to your next story, too, with Alex Murdaugh. They're going to have to ask the same question. But yeah, I think it does. I don't think they would admit to us, Carell, that that's factoring into their decision. But the fact that Harvey Weinstein is behind bars likely for the rest of his life, I think that plays a big part in this, because he's going to be in jail for likely the rest of his life. And then the other thing you have to consider too that I didn't mention is prosecutors will consult with Mann, the victim, and they said they would do that, and they should do that, because she has to endure another round of trauma. That's got to be your first visit, to ask her, do you really want to go through this again? How do you feel about it? And I think when you combine those two factors, like I said, I just don't think we're going to see another trial with Mann.
Well, Brian, we do have another major legal case that I want to get to next. You mentioned it quickly there, Alec Murdaugh. I'm going to put up some video here of Alec Murdaugh, just give a little bit of background context to this whole situation. So his murder convictions and life sentence for the deaths of his wife and son were overturned on Wednesday. It was a unanimous ruling by the South Carolina Supreme Court. They said the conduct by the county clerk there of court, Becky Hill, quote, egregiously attacked Murdaugh's credibility by suggesting to jurors his testimony cannot be trusted. Brian, how serious is this violation? And more importantly, was it surprising to you that it led to the overturning of a conviction and that sentence?
Hey, Carl, first of all, for your viewers, having a murder conviction overturned is like 1 in a zillion. I mean, there's less than 1% of cases that ever even get overturned like this. But I was not surprised. Why? For 2 reasons. Becky Hill's conduct was a catastrophic failure on the part of the prosecution. Why? Because no matter how much we might not like Alex Murdaugh, we might think he's a murderer, he's a bad guy, he lied and cheated and stealing money from clients allegedly. The fact of the matter is we have a constitutional right to a fair and impartial jury. And the clerk of the court is not supposed to be communicating with jurors except to instruct to give them an oath, right? That they're going to negotiate in good faith, and then to put them back and tell them when to come and go, right? To manage the logistics of the jury. When do they come and go for lunch? Having them exit, making sure they're not talking to anybody. The fact that she's suggesting to jurors to not trust Murdaugh, or she also said, Carell, oh, check out this guy's body language, right? I don't think you're gonna, look at his body language. It might affect your decision. That's just out of bounds. I'll give you a quick example. I had a big criminal trial years ago on a high-profile case I told you about, and I said hi to a juror in an elevator, right? I'm going up in an elevator. I said hello, good morning to a juror. That was reported to the judge, and I was chastised by the judge and told I better not say another word to another juror. That's how strict those rules are. The second point I wanted to make real quick is there was 12 hours, almost 2 days of testimony of financial crimes that Murdaugh committed. And I think the jury got this one right too. The jury said, you can't testify for that long about the financial crimes as the motive. Why? Because in courts across the country, we have a doctrine called bad character evidence. In some courts, it's called inadmissible character evidence. What does that mean? That you can't put on evidence of another crime or wrongdoing to show that the person committed this crime that's before the jury.
Prosecutors are saying that they plan to retry Murdaugh, which likely means there will be another lengthy trial for this case. This is just some footage that we have here because this case specifically, also Harvey Weinstein's, I mean, a lot of documentaries have been made because of these high-profile cases. But walk us through, Brian, what's going through the defense's mind right now as they prepare for yet another trial. What are they going to make sure they bring into the courtroom to make sure that this conviction it doesn't stick, for example?
Yeah, that's a great question. I mean, let's take a look at the evidence. Aside from putting aside, Becky Hill's conduct, I think the prosecution has an incredibly strong case. I think the two most powerful pieces of evidence the prosecution have is Murdaugh lied about how long he was visiting his mom. Remember, he testified at trial. Oh, look, when this alleged crime took place, I was out visiting my mom. She's unhealthy. I was there for 3 hours. Well, they had two things. They had GPS on his phone, and then they also talked to the caregiver, right, of the mom. And she said, wait a minute, he was only there 30 minutes. So that's devastating because that puts him arguably, it gives him time to get to the scene of the crime. And then I thought by far the most powerful and profound piece of evidence in the case was, remember, Murdaugh testified at trial that he was not near the kennel, the dog kennel, where the alleged shooting occurred. And remember, they found like a video. It was either a video or an audio where you could hear Murdaugh's voice in the background with his son at the kennel within 20 minutes of the shooting. I mean, that testimony is just devastating for Murdaugh. So I think in the next case, they're going to trim the evidence of the alleged financial misconduct. That's going to be maybe an hour of testimony. And then if they can just avoid any misconduct of courtroom employees, I think the evidence is going to lead in this case to a probable conviction.
All right, so both of these cases, obviously there's a lot to talk about with them, but before I let you go, Brian, they're both very different in terms of the moves that we saw earlier this week. One is a mistrial. One of them is now going to be a retrial going forward, or an overturning of a conviction, which, as you said, was, not something that happens really too often, very rare. When I was reading up on both of these trials, with Weinstein specifically, I found things that I thought were a bit similar. So Weinstein was initially convicted back in 2020. An appeals court overturned that verdict after the court ruled that the trial judge unfairly allowed testimony against Weinstein based on allegations that weren't part of the case. Similarly, with Murdaugh, justices in this latest ruling, they had warned the next judge that was going to be trying this murder case to be cautious of how much evidence of Murdaugh's thefts from his law firm and his clients were going to be allowed for the jury to hear. Based off of those two facts there, how common, Brian, is it to present evidence at a case against a defendant that doesn't specifically have to do with what they're on trial for? And what does that do overall with the argument?
Yeah, that's a great observation on your part. Before I answer that, I wanted to add one other quick point about the retrial of Murdaugh. Prosecutors really have no choice, Carol. Why? Because this was one of the most high-profile murder trials in, 10, 20 years? There was a documentary done, I think, on Netflix about it. So prosecutors would face a world of criticism if they didn't see this case through, right? That was another factor why they're going to do this. And then back to your question, you're exactly right. In nearly all criminal trials, you are not allowed to bring in any evidence of a prior alleged crime or prior alleged misconduct. Why? Because as I said earlier, what it does is it can taint a juror, right? If you're sitting there, Carell, hey, do I vote guilt, innocence? Gosh, I'm on the fence. What do I do here? If you hear evidence that Weinstein may have done this to another woman, or Murdaugh is stealing money, for example, from his clients, that is going to infiltrate your body and your soul, and that could very well lead to pushing you and moving the needle over to a conviction. And that's why courts are super, super careful to not allow that type of evidence into a trial. And I think Weinstein, they made the right decision. I think Murdaugh, they're going to narrow it. They're only going to allow it, by the way, for your viewers to know. It's only admissible to prove motive. And the judge has to give a really careful instruction on that too, so that jurors don't just take that evidence and run and say, hey, if this guy can steal money from a client, he's guilty of murder. Hey, if Weinstein did this before to another lady, then he likely did it here. We have to avoid that from happening, because that would violate constitutional rights of the defendants.
Brian Claypool, a criminal defense attorney. Brian, always good to have you here at Live Now from Fox to break down these legal cases.
You bet. Thanks, Carol.
Of course.